Hey. Let all persons having business before the Supreme Court of the Virgin Islands join and give attention. For this court is now in session. The Honorable Reese S. Hodge, Chief Justice. The Honorable I. Arlington Swan, Associate Justice. The Honorable Harold W. L. Willax, Associate Justice, presiding. God save the United States, Territory of the Virgin Islands, and this Honorable Court. Please be seated.
Good morning, everyone. Start with the calendar, with the case Lime Tree Bay Terminals LLC versus Vincent Liger, and that is number 45 of 2023. Counsel, you ready?
Yes, Your Honor. First of all, good morning, Justice Hodge, Chief Justice Hodge, Justice Swan, and Justice Willax. And a special congratulations to Justice Willax on his future on this court. So it's exciting times.
Thank you. This is his first sitting as an Associate Justice of the Court, and we're happy to have him. Okay,
He'll be sorely missed over in St. Croix, I will say.
Do you, you wish to reserve any time for rebuttal?
Yes, I would reserve 5 minutes for rebuttal.
It was all of your time. The government will not argue, and so you've got your...
I understand. Thank you. So may it please the court, I'd like to briefly provide an introduction, statement of the case, and a synopsis of my argument, and then answer any questions that the court may have.
I have a whole lot of questions.
Hopefully I can answer them.
As a matter of fact, I am sorry that I'm not afforded a full hour.
Maybe I should reserve 10 minutes. No. So basically, we're here on a limited issue as to whether Section B4 is constitutional under the VI Organic Act. And the issue specifically is separation of powers and also equal protection. It is appellant's position that the matter can be decided on separation of powers and there's no need to go to equal protection, but the statute is unconstitutional under both grounds. The case is interesting, and I think it's important to note. This case arises out of a release by an entity, Lime Tree Bay Refining, that was doing a startup in early 2021, and specifically this case relates to a release in May of 2021. As the court's aware, there were some related cases that were filed within about 3 weeks, some class action lawsuits. This case came along about 1.5 years later. Mr. Liger, who filed a separate action in the Superior Court and specifically pled to avoid federal jurisdiction and limited his damages to $75,000 and limited his recovery to sole several liability and not joint liability in order to allow the case to proceed with the Superior Court. And he also indicated that he was going to file for a preference, and he kept the case simple on its face, but yet it's a very complex case underneath. He only pled nuisance. And when he filed, he then amended the complaint about a month later. He had named the Lime Tree Bay Refining, the entity that actually did the startup, as well as an entity named Ventures, and then Terminals. He eventually dismissed both Ventures and Refining and only proceeded against Terminals. There had been relayed through his counsel that there were a number of other cases involving elderly parties, and so Lime Tree Bay Terminals sought to designate the case as complex. And it got stalled briefly before the complex division, and the court ultimately said, well, the cases aren't here, so it's not complex. No scheduling order had yet been entered by the Superior Court. And then Mr. Liger, the party, the elderly party, moved for the preference. It was briefed. The constitutionality was challenged immediately. And Terminals raised immediately the fact that discovery was basically in its infancy, there was no scheduling order, and that the case just hadn't really gotten off the ground yet. And the Superior Court ordered a preference trial, and by the time the court ordered the trial, it was set for 7 weeks later. Now, mind you, there'd been limited written discovery at most, no scheduling order, and the trial was set for 7 weeks. And this involved a nuisance that wasn't like a tree branch over into your yard or a loud noise from a neighboring house or anything like that. It was a question about whether the refining entity had released hydrocarbons that had landed on Mr. Liger's house, which is a very complex case just to meet burdens of proof and to defend against. By the nature of the order setting the trial in 7 weeks, under this court's rules of civil procedure, the 90 days in advance of trial to name experts had already passed. Terminals was put in a box, a position that forced it to prepare as best as it could for a trial in 7 weeks of this magnitude with significant complex issues. Your Honor.
Was the 7 weeks because of the date that he filed the motion?
Correct. The 180 days from the date of the filing of the motion would have expired right about a couple days after the original date of the trial that was set by the Superior Court. I believe the trial was set, I have it in my notes, but it's in the joint appendix. I want to say July 30th or 31st, and that was just up to the 180-day mark from when the preference was requested. So to answer your question, the 7 weeks was what was left in that time frame. Up until that time, there had been litigation.
Is that because it took the court basically 4 months to decide?
Correct. Correct.
Tony, we have an even greater problem for the Superior Court judges who all have to deal with this piece of legislation. And let me explain to you what I meant by that. Am I correct that the Superior Court is a court of general jurisdiction?
Correct, Your Honor.
And am I correct that general jurisdiction means it handles both criminal cases and civil cases?
Absolutely correct, Your Honor.
Good. Am I correct that under Article 6 of the United States Constitution, that it says that the Constitution and the laws made in pursuant thereof, which is our Revised Organic Act of 1954, and the treaties made in pursuant thereof, shall be the supreme law of the land? Am I correct?
Correct.
Right, okay. It's all sixes. Let's go to now Amendment 6 to the United States Constitution. And it says that in all criminal prosecution, the accused shall enjoy the right to a speedy and public trial. Am I correct?
Correct.
And am I correct that the Sixth Amendment is incorporated into Section 3 of the Revised Organic Act?
I believe you are correct, yes.
Okay. Then am I correct that the Superior Court now is faced with given a problem with moving the criminal cases if in fact that everybody is going to be entitled to it? It doesn't make a distinction between felonies or misdemeanors, that they're entitled to a speedy trial. Am I correct?
You are absolutely
under
correct.
Baker versus Winger, which is the iconic Supreme Court case, everybody now has become entitled to a speedy trial. All right. Now, we don't have, the feds have the Sixth Amendment, we have the Sixth Amendment. The feds have a Speedy Trial Act, we don't have it. But it is very, very important that what the feds did, that they recognize in terms of priority among the cases that are filed in the district court. And it says that for all intent and purposes in the Federal Rules of Civil Procedure, that criminal cases would be given priority.
Correct.
And so why should we not, under the Sixth Amendment or our Revised Organic Act, that we have to follow in terms of the Speedy Trial, not necessarily the Speedy Trial Act, but make sure that all criminal proceedings is subject to the speedy trial. Yet, what this legislation does is usurp the authority of the Superior Court judges to even meet that requirement. Because to me, there is absolutely, Rule 50 of the Federal Rules of Criminal Procedure, this is what it says. Scheduled in preference must be given to criminal proceedings as far as practicable. We don't have that, of course. We don't have a Rule 50 like the feds in the federal rules of criminal procedure. But here is the thing, though, is that for all intents and purposes, this legislation, I don't see how with our rule, and it's all sixes, Article 6, Amendment 6, and then we now go to 16 and 26. 16, which is the scheduled-in orders for civil cases in the Superior Court. And then we go to Rule 26, which have the discovery. When you look at those two rules, Rule 26 and Rule 16, is there anybody who could seriously believe that a civil case for personal injuries can go to trial in the Superior Court within 180 days? It's almost impossible, because the minute that you start talking about personal injuries, you have all kind of expert depositions to be taken, fact deposition, expert deposition. You're going to have medical witnesses. You're going to have economists coming in talking about loss of income going forward. We even have some punitive damages and all that in there. Knowing that we have knowing that the Superior Court is a court of general jurisdiction, and it must adhere to the United States Supreme Court, the Sixth Amendment, and for all intents, Barker versus Wingo. How is a docket under the civil side is ever going to get within 180 days, given the extensive and elaborate and
If I may,
terms of Rule 16 and Rule 26. Hold on, I'm not finished yet. Because the next thing is that why do we have to give anybody preference in a civil case when we have Rule 90? You know what is Rule 90?
I do know Rule 90 in the Civil Rules of Procedure.
Yeah.
Yes.
And what is it?
It's regarding the coordination of potentially complex cases.
No. Rule 60 talks in terms of mediation.
Oh, Rule 60, I apologize. I thought you said Rule 90. My apologies. Yes.
I did say I'm 90. It is Rule 90. It used to be 40 years ago.
I remember.
And we went and we changed it. And also that anybody that filed a civil case in the Superior Court, they have an advantage. Why? Because they could always have a settlement conference under Rule 16 with the judge. They can go to mediation. And not only that, but for all intents and purposes, am I correct that even if they want, that we have a mechanism under our rules in the civil side to preserve witnesses' testimony by way of deposition. Am I correct?
You are correct.
Absolutely. And not only that, but am I correct too, that we have something that even if somebody like me dies at the age of 90, and if I have a good cause of action that survives the action, it could still go forward.
Correct.
And if any recovery is made, it can go to my estate.
Correct.
So given now that the dilemma that this piece of legislation has put Superior Court judges in with the Sixth Amendment and Section 3 of the Revised Organic Act hanging like a draconian sword over the judge's head, this law has really disrupted the proceedings in the Superior Court. When you talk in terms of, look at the amount of even interrogatories under Rule 33 of the civil rules, the Virgin Islands civil rules. you serve interrogatories at least 30 days to answer. And that's just the beginning.
Right, and in
That's
this
just the
very
beginning.
case, interrogatories were
And everything now
propounded that
go
were due
forward
at the
in
day of
terms
trial.
26 and 16. How in God's name can anybody gonna get anything done within 180 days that it shall be go to trial in 180 days?
If I may make a point, Justice Swan.
Before you go on, you would agree that if the court is correct below, that this is a substantive law, that the legislature would have the authority to enact it?
So with respect
And just
to,
answer it. If it's substantive, then it's within the legislative range to enact.
yes, if any.
Okay, tell us why this is procedural rather than substantive.
Yes, it's procedural because this case, this statute is related to enforcing the right to a substantive trial on the merits of your claim. Mr. Liger has an underlying nuisance claim, and that claim, he has a right to a trial and due process on that. And this statute is designed to allow enforcement of that right to have that trial within 180 days. And because it's enforcing a right, it's a procedural statute. And if the entire statute itself isn't
Well,
considered
I'm sorry.
procedural,
Excuse me, let me ask this. Continuances, are they procedural or substantive?
continuances are
Yes.
procedural.
The procedural, okay. The setting of dates of cases, is that procedural or substantive?
Procedural.
And just stepping away a quick second, you would agree that the elderly is a protective class, do you not?
Excuse me, that the elderly
Excuse
what?
me. That the elderly is or can be a protective class. You would agree with that?
The elderly has certain characteristics, be it their age, and the legislature could choose to provide them protections.
Well, all of that is a given. I'm asking you, well, let me rephrase the question. Do you have any issues with the manner in which the legislature, identified the elderly as a protective class?
I know that that wasn't briefed in this particular appeal, but I do believe that the establishment of, because the legislature talks about a party, not necessarily a person, and it talks about a party, and all parties, corporations and people are persons before the eye of the law. And so the statute as written, I believe, would not pass muster under this court's heightened scrutiny test that it has adopted for looking at equal protection under the law.
You say we don't need to get to that, correct?
I do. I think we can answer this question on separation of powers,
Well,
absolutely.
What about Section 21 of the Revised Organic Act? Does not seem to suggest that the rules of procedure in the Superior Court should be promulgated by the courts, all the procedural rules, because anytime that you start talking about time limit, when this has to be done and that has to be done, there's nothing substantive about that. It's all the procedure moving towards, and it's tantamount to almost Rule 16 and Rule 26, trying to get the case expedited as much as possible, as Rule 16 of the...
Which is why this
General
court's
Rules
civil
of,
rules
Civil
should
Procedure
prevail.
says.
That's why this court's civil rules should prevail. And what I wanted to mention, while I agree with you, Justice Swan, that the stars would have to incredibly align to allow a personal injury case to actually happen and all due process rights of the parties be protected within 180 days, that analysis that the appellees advance about the no set of circumstances actually fails because it misses the point. This legislation has put into the hands of parties the right to demand a trial be set within 180 days. So it's not the court making a decision. And so
Absolutely.
that's where the conflict
Absolutely.
is, because
And-
the court's hands have been tied
and-
by a party through the legislation empowering that party to say when
And
the trial
that is
can
my
be.
point, because what this legislation has done is wreak havoc on the Superior Court. Not only wreak havoc, but havoc on the right the inalienable right of the Superior Court to determine its calendar.
And exactly.
And locking behind of that is preferential treatment to be given to criminal cases. How in God's name can anybody believe that given the state of litigation in civil cases, even involving personal injuries, and the time frame for deposition, for conferences, for this and for that and for the other, that anything can be done within 180 days? This law seems to be, it's going to create a disaster for the Superior Court judges.
Correct.
Counsel-
And it also,
Counsel, thank you. You can,
thank you, Your Honor.
Good morning, Justices.
Good morning.
Morning.
My name is Warren Burns, and I represent Mr. Vincent Liger, the appellee in this case. Justice Swan, as I was sitting there listening to the argument, I was reminded,
let's hold on,
okay.
hopefully let the generator kick in.
Open on Hornets, that's what I like it. So let's get to it.
Okay, go ahead.
Hopefully that's not portentous, but I was reminded that my father would probably tell me that I have a pretty hard row to hoe with you on this point.
Pardon me? Oh, you said what?
My father would say I probably have a pretty hard row to hoe with you on this point, given your concerns about the impact on the judiciary. But I am here actually to ask this honorable court to decline the invitation that the appellants have made to make this case something is not. And I want to start with your questions, Justice Swan, because they're pivotal to this. Act 8468 was enacted on August 16th, 2021. During that time, 2 Superior Court judges have looked at this act in depth, found that it was substantive in nature, and otherwise did not conflict, even if it were procedural, with procedural laws in the Virgin Islands. And the courts have gone on about their business. They've gone on about their business in part because, as Judge Andrews in the NRA refinery workers case recognized, that notwithstanding the right, which you heard counsel for the appellant admit here today, that this was a right that was conferred by the legislature on residents of the U.S. Virgin Islands. Notwithstanding that right, certain discretion is left with the Superior Court in this case.
What discretion is left? What is the discretion? 30 days continuance for
It's more
physical
than,
injury only?
I'm sorry, Chief Justice Hodge.
No, I'm saying what is the discretion?
So I would direct the court to Section 6 of Act Number 8468. And what Section 6 provides, if I may, is that it begins by saying, unless the court orders otherwise. That's the preamble to that section. And then it says, at any time during the pendency of the action, a party who reaches 70 years of age may file and serve a motion for preference. In Judge Andrews,
That's not discretion. The only discretion is that the judge can change the requirement that they certify that the person has been served or has appeared in the case.
and I don't want to misspeak here. Here is whether it's discretion, freedom, liberty, however it would be termed in this case. Chief Justice Hodge.
Attorney, I don't understand what you're saying that there's any kind of discretion, because it says a party to a civil case who is over 70 years of age or older may petition the court for a preference, which the court shall grant if it finds that the party has a substantial interest in the action as a whole. Then it goes down. And then later on, they use a lot of shall in there. And so for all intents and purposes, this law seems to be kind of, in many ways, not discretionary.
That is correct, Justice Swan. And I don't want to trip myself up, frankly, on this issue. Let me just explain in simple terms what I mean. It's actually what Judge Andrews says in the NRA refinery workers decision. toward the end of that decision, he says, look, this is not going to have a major impact on the superior courts, and here's why, and he gives two reasons. The first is he points to Section 6, and he says, under Section 6, I, as the superior court judge, can set the time for the filing of the motion. So I can set into my order that the motion can't be filed until, for example, the plaintiff's deposition has been taken. Now, in effect, and actually,
Where does that authority comes from?
that authority comes and he points to Section 6 of the Act.
But the
which-
only thing that the Section 6 says is that it can, I guess it have some discretion as to when it can be filed, that the person has to certify, so it takes out that 120 days, whatever it is, to serve someone, and that a person who, when the case is filed, may be under 70. The minute they reach 70, they have a right to file it. So I don't know what the discretion is in that section.
So, Your Honor, it's simply this. They
Well,
do.
I have the same concern as the chief, because I'm looking at Section 6, and I don't read into Section 6 what you were saying. But if you can point to me the specific language, I'll appreciate it. At any time during the pendency or action, a party who reaches 70 years of age may file and solve a petition for preference. But once he filed a petition for preference, does that kick in under Section 1, B1?
So, Justice Swan, you're missing actually the words that appear right after parenthetical 6, which states, unless the court orders otherwise. And here is the key. What the court can do, and what Judge Andrews did in subsequent cases, was order that a motion for the preference, which by right belongs to the plaintiff, could not be filed until after the plaintiff's deposition had been taken. The effect of that is to ensure that certain minimal discovery or under any particular scheduling order, that degree of discovery can vary, but the discovery can go forward. Up to a point where the judge specifies, and the Act's words are what they are, unless the court orders otherwise, and in this case, Judge Andrews ordered otherwise,
I'm
that
sorry,
the time.
excuse me a
for-
second.
Sure.
One judge decision does not bind another judge, is it correct? So this is not something that is universally accepted throughout the Superior Court. This is the Honorable Judge Andrews in handling one particular matter. So another judge may look at that totally or completely different. Am I not correct?
That is correct. Another
Okay,
judge
okay,
could
great.
not specify, for instance, that it be filed on a certain day.
That's understood. So your continuous use of Judge Andrews' opinion is going to be dependent upon another judge's use of that rationale. Am I not correct?
That is correct, Your Honor.
Okay. Now, you would agree that a substantial part of this act is procedural. There are some substantive parts in there, perhaps the first maybe 2 paragraphs, but the rest goes directly towards the judge's ability to set cases, the amount of continuances to be given. That is clearly procedural. Am I not correct?
I would not agree with that, Your Honor.
Well, it's in black and white. You're allowed 1 continuance. It must be done within, trial date must be set. There's no discretion. You're allowed to do for medical. Where's the discretion of the trial judge? I mean,
So in this case specifically, we're dealing with Section 1, which deals with persons over 70.
yeah, but my
So
question
you're
is,
correct
just
that,
a second, please.
sorry.
My question is, where in this is there discretion, except for stated by the legislature, where in is there the discretion that the trial judge can say give 2 continuances or even 3 continuances?
So, Your Honor, specifically with respect to continuances, the statute specifies that only 1 continuance for
Absolutely.
physical disability.
Which is
can
a
be set.
procedure within the court, discretion fully of the trial court.
But as long as it is within the 180 days, there can be multiple continuances. I'm not saying, the trial has to be set within 180 days.
Exactly, procedurally.
Not procedurally, Your Honor, and here's where I disagree with you.
Okay, let me just ask. So the setting of 180 days is not a procedure?
It is not, Your Honor. That is the right conferred by the legislature on the
You
plaintiff.
may call it whatever you wish, but it's a procedure. Procedure, and its case law backs this up. Procedure is continuances, setting of trial date. You may look at it as substantive right, which I guess to some extent you can, but it is in fact procedural because it goes to the setting of a trial date.
In the ordinary course, I would fully agree with you, Your Honor, but here we're talking about a specific right that is conferred by this statute. And ultimately, the court has set the standards for determining, this court has set the standards for determining whether a statute is procedural of substantive, and that's World Fresh Markets, 74 VI 461. And the words the court used there were very important. Set a substantive rule of law, on the other hand, creates and defines the rights, duties, and obligations that are subsequently administered by procedural rules of law. And what both courts below that have dealt with this issue and what I submit to the court today is that the legislature created a right for persons over 70 years of age to invoke the preference for a trial within 180 days.
And I'm in agreement with you. But didn't the legislature go too far when it got into the procedures? They can establish the right, clearly, but are they not getting into the separation of powers issue, which this court has said that procedurally, if the legislature, the laws from the legislature conflicts with the rules or the rules with the rules established by this court, it is infringement on the separation of powers. And I'm saying to you, there are, in my opinion, anyhow, there are two parts of this statute. One is substantive, which allows the legislature clearly to give that right. But then the legislature step too far in saying, and this is what I want the Superior Court to do. You must do it this way and start getting into the procedure. How the legislature just simply said, look, you may petition the court for preferential treatment. If you're 70, you're terminally ill. The court shall establish rules and regulations to put or to have this preferential treatment implemented. We would not be here, would we? It's a yes or no. We would not be here, would we?
We would not be here if the
The
legislature
legislature
enacted
simply
that
said,
statute.
the court shall establish rules and regulations in which to implement the preferential treatment.
I think you're right, Your Honor, that that's a different case, obviously.
No,
a different
it's
statute.
just a fact scenario. I'm simply saying, your argument to me is somewhat a mixture of the two. Clearly, the legislature has the right to establish preferential treatment, but it does not have the right to go into the procedures in which the Superior Court establishes. So your argument, and I agree with you, clearly they have that right. But and I guess my last question is, are they not going too far when they start establishing all these procedural rules for the court?
I think that
No discretion at all. I know you're trying to find some discretion in Section 6, but
But I'm actually not trying to take that too far, Your Honor. I am not here to tell you that this is a discretionary statute. It is not. It clearly, by its terms, is not discretionary. But that's the point. The right conveyed or conferred on the plaintiff by the legislature was a right, once making that motion, to get the trial within 180 days. So the right circumscribes, that is absolutely correct, the right circumscribes the outer limit that a court could actually bring the case to trial. Within that, there's a certain amount of discretion, and I am not here to tell you it's a lot. But there are marginal pieces of discretion within that calendar. But ultimately, the right conveyed circumscribed.
with respect to, we're only here with respect to the 70 age, correct? We're not here about whether someone is terminally ill, whether someone has 6 months to live. We're just on the age 70, 180 days with one continuance.
That's correct, Your Honor. The only issue before the court is that section.
And where's any discretion in the judge other than to grant that one continuance.
Yeah, you know, essentially within the, within that provision and the subsequent follow-on provisions, I think that is the primary piece of discretion, which is if a court set the trial date within the 180 days, but not outside it, it could potentially grant more than one continuance for good cause, not for physical
How about
inability.
the situation where the judge must set the 180 days from the date the motion is filed, not even if it rules on it 6 months later, or 4 months later. It still can only set it for 180 days. Does that seem like something that
It seems like a rapid schedule. I agree with you.
rapid? It seems like there's no schedule.
I'm not walking.
In this case, the judge, you know, I believe the motion was filed on January 30th, and the court didn't rule on it until June 7th, I believe. So, and
Well, but in this case, Your Honor, I think that actually demonstrates where a certain line can be drawn if you're looking at the statute. So the statute circumscribes the 180-day limit on this hand. It does not tell the judge when it has to rule, or when the court has to
Right.
rule, or how it has to rule,
But then,
or,
excuse me,
or,
but then, yes, but then wouldn't that be exposing the judge for writ of mandamus? Because there are other rules that require judges, trial judges to rule within a certain period of time. So would it not be exposing that particular judge if, for example, judge sits on making that motion for 8 months? What stops the moving party from filing a writ of mandamus against that particular judge because they failed to rule on the motion?
well, in that case, there would be nothing to stop the moving party from filing mandamus, nor would there be anything barring the non-moving party from challenging, at least in an as-applied.
Attorney, I think
position.
that what we are doing is that we're going around the mulberry bush. What this law has done is that it has gone into the scheduling of cases, it has gone into the discretion. As a matter of fact, it has invaded the judicial branch. Because what it has done is that, you know, you can give somebody a right, but when you start telling the court, you have to schedule X, Y, Z, then you have gone to the docket of the court. You are telling the court, within 180 days, you shall have a trial on this, irrespective of anything else. And there's no discretion there. But you can, nobody is not saying that the legislature can give a right. But when you come to adjudicating that right or whatever, or that preference, and you're going to involve the judiciary, and you're going to get into the operation of the judiciary, and take away from the court, the judge, the full discretion and authority to control that judge's docket, who now also have to worry about what? The Sixth Amendment. Speedy trial. You know, in a jurisdiction that have the civil division and a criminal division, then this here, well, there might be some leeway. But where we have just a uniform general jurisdiction, and Judge, for all intents and purposes, Justice Willax, I call him Judge, but Justice Willax is absolutely correct. This court is going to be inundated by a deluge, an avalanche of writ for mandamus by both the criminal defendants and by the civil plaintiffs, when the court cannot, there's only but so much time when the court cannot meet this, the language of this statute. I don't think that the legislature had really thought this thing through, or at least did not. I don't know if it had any input from the Superior Court. But I noticed that the legislature, from my reading, was concerned about elderly people getting their day in court because of their advanced age, or they might be terminally ill. But for all intents and purposes, there's such a thing, you know, they have deposition to perpetuate testimony. That's Rule 27. They can utilize that. They can utilize the pre-trial conferences or settlement conferences. They can go to mediation. And then under 5 VIC 77, survival of a tort action. So, so it's not like the elderly, because of advanced age, doesn't have certain other alternative remedies. But when it comes to the court's docket and telling the court when to schedule its cases and what kind of cases to schedule, this is what this is doing. It has done that. And I will tell you, a lot of criminal defendants are going to be coming up here and they're going to invoke something which is called the Sixth Amendment.
Just let me ask you, what right did the legislature create in this case? The person already has a right to a trial, has a right to a jury trial, has all access to the court, and the only right that is created is a procedural right to have the case heard within 180 days, basically?
No, Chief Justice Hodge. And the reason,
Okay, why?
if I may state it this way, the right they created is the right for a plaintiff to seek a preferential setting that guarantees a trial within 180 days. It is analogous, I submit to the court, to the Sixth Amendment that Justice Swan has referenced multiple times. The only difference is the legislature here specified within 180 days. But I will tell you, in the history of our republic, no one has ever said the Sixth Amendment right to a jury or to a speedy trial is procedural, not substantive,
But that's-
even
that's-
though it circumscribes
Counsel-
the court's
Yeah,
actions,
Counsel,
as you've
that's
pointed out.
that's
a
completely
totally
different.
different thing. That's a
completely
totally different thing.
Totally different.
That's a
But-
totally different thing.
And even though I would tend to say, yes, the legislature have a right to recognize the elderly, granted, they may not have done it, well, the old adage, the road to hell is paved with good intentions. They may not have done their due diligence, because I would challenge you or anyone to tell me the amount of cases, for example, before the Superior Court, in which they're terminally ill, in which there is plaintiffs over 70? Or are you aware how many cases before?
How many
the-
cases exist in front of the Superior Court at this
Yes.
time? I'm not, Your Honor.
Okay.
I'm
How
not.
many are there in which the plaintiff is 70 years old or not?
I can't tell you that, actually. I haven't
My
pulled
point
that,
exactly.
Your Honor. That's
So I'm saying, even given those weaknesses or faults in which the legislature established or give the right to those who are 70 years old or terminally ill, you still can't change, it is what it is. This legislation has gone too far. It's gone into procedures. And you cannot establish a right to a procedure. And that is basically what you're saying. And I'm saying, no. You can establish a right for preferential treatment. I mean, I guess it is somewhat laudable, even though I know that the full intent of the legislature wasn't necessarily to identify the class, but rather to send a message. I get that. But I have no problem with the identification of the elderly or the terminally ill for preferential. But you can't say that you can establish a right to a procedural in the court. And you would have to admit that you may say, oh, it's a substantive procedural right. You may try and do a hybrid, but it is what it is. These rights are procedural.
Your Honor, I certainly respect the position and understand what you're grappling with here. And it principally relates to, in my understanding, this imposition of a specific and hard deadline of 180 days afterwards, which you think, judging from these comments, and I don't want to prejudge your ultimate position, but I understand the concern that strays somehow into procedure. But I will say this, the legislature sets deadlines all the time, including in the judicial context. So, for instance, with respect to statutes of limitations, the legislature can say a claim may be brought, but it has to be brought within a certain amount of time. It has to be brought within 1 year or 2 years. It's still setting a deadline that otherwise cabins the court's procedure. A court unfettered by that deadline might be willing to engage
Counsel-
in
Counsel.
other practice.
Does it say, and within the 2 years, you must file a motion in 6 months? You cannot have a continuance? You're allowed one continuance for X reasons? Does it go into that minute detail? Or does it simply say, you try a case within 3 years jurisdiction? Does it not just establish a jurisdiction? Does this legislation simply establish a jurisdiction? Or does it not go further into the very minute aspects of it?
In fairness, Your Honor, I've never seen a statute of limitation that went into those type of details. So you are absolutely correct.
My point exactly.
Yep.
Thank you.
But I'll leave you with that analog for
All
whatever
right,
it's
thank
worth.
you.
Thank you for your
Thank you.
time.
All right, you get just as much time over as the plaintiff did. You got 8 minutes and 42 seconds.
And please, the court, Justices, I really only have 2 comments in
Right, move
response.
the mic up and speak directly into it.
Excuse me?
No, just move it up a little since you're a little taller. Go ahead.
Okay. Can you hear me now?
Yeah, we can hear you well, but it's how it's going through on the live stream.
I see. All right. I just have 2 comments to what was stated by the appellee. One is with respect to Section 6 and this idea that the court can set a time in the schedule when a party can make the preference. And that is a case-centric view, and it doesn't take into account many of the things that Justice Swan brought up about what's going on before the court in other litigation, right? So that even if the court were to say, after a plaintiff's deposition, now you can make your preference, they make the preference, the court still has to order that trial within 180 days. And so if something comes up, for example, a speedy trial or a criminal case or some type of injunctive relief that needs the court's attention, the court may not be able to juggle the calendar and shift the trial date. It's deprived the court of that ability. So Section 6 does not cure the problems with this statute that make it unconstitutional under the Organic Act. The other thing I wanted to point out is that I frankly believe the record shows that the legislature knew this was doomed to fail from the beginning. And I note that Senator Potter stated that they recognize clearly the judiciary has the ultimate say as to how it chooses to manage its docket. But if nothing else, this bill will send a message that the legislative branch is concerned with the docket not moving. I mean, that's exactly right. Your Honor has, and frankly, the old civil rules, as the court's well aware, were promulgated by the Superior Court, but now this court has promulgated the rules of civil procedure, and those rules more than account for and take into consideration the fact that a elderly or a terminally ill person can move the court for a speedy resolution of their case. So this court's rules of civil procedure are definitely in direct conflict with this statute. So those are my 2
I'm
comments.
sorry, just one quick question. Is there anything in the rules that prohibits or stops an elderly person or terminally ill person from moving the court for an expedited trial based on their age or that they are terminally ill?
Absolutely not. And in fact, we would bring in Rule 1, so 1 without a 6 in it. But Rule 1 actually imposes a responsibility on the trial courts to do speedy, just, and inexpensive determinations of their cases. So if a litigant wanted to move for that, they could, and the court has given the trial courts, this court through the rules of civil procedure, has given the trial courts full discretion to be able to move that case up on the docket and take into consideration all of the substantive rights of all of the parties, so that other defendants, maybe even other plaintiffs, as well as the substantive rights of other parties before the court in other litigation that is outside of the case with the elderly party or the terminally ill party.
Okay,
Thank you.
thank you. The matter will be submitted.
All rise. stand until your honors leave the courtroom. is over. This court is now in session. The Honorable Maria M. Cabret, Associate Justice. The Honorable Harold W. L. Willax, Associate Justice. The Honorable Jomo Mead, Designated Justice, presiding. Please be seated.
Good morning. The first case that we will call today is the Government of the Virgin Islands versus Kenrick Maynard.
Good morning, Justices, and may it please the Court. My name is Assistant Attorney General Sean Bailey on behalf of the government appellants in this matter. I would request to reserve 5 minutes for rebuttal.
Very well. You may proceed.
The Superior Court in this case erred in granting habeas relief to the petitioner because the appellee failed to carry his heavy burden established by the United States Supreme Court in the Strickland case. In this case, appellee failed to call his trial counsel as a witness during the habeas hearing in this matter, which this court has already described as generally fatal to habeas relief in the Blyden case. Moreover, the appellee failed to produce a copy of the treatment record of the key witness in this case, who the appellee contends trial counsel failed to investigate. So appellee failed to produce a copy of that treatment record, which is the basis on which the Superior Court granted relief in this case. The appellee failed to demonstrate that the treatment record would be admissible, and also failed to show that even if that testimony of the witness was found not to be credible by the jury, that the result would be any different. And in this case, there was indeed plenty of other evidence to support a conviction of the appellee. Given the appellee's failure to produce trial counsel as a witness or to produce a copy of the record or demonstrate admissibility, the Superior Court's ruling in this case is effectively based on little more than stacked assumptions about what those records would have shown, whether or not they may have been admissible, and whether or not the jury would have credited it and or still found Maynard guilty, whether or not the challenged witness was found credible or not. So under Strickland, the petitioner must identify acts or omissions of counsel that are alleged to have been outside the wide range of reasonable professional judgment and competent assistance. In this case, the petitioner failed to do that on several levels. First of all, under the Blyden case, as I've already alluded to.
With regard to the Blyden case, did this court categorically state that unless you call trial counsel in an ineffective assistance of counsel case, you can never prevail?
No, Your Honor. Blyden did not establish a categorical bar to success on a habeas petition in the absence of testimony from trial counsel. However, what the court did say is that because the court has to presume that trial counsel acted within the scope of reasonable professional judgment, and because a habeas petitioner bears the burden of rebutting that presumption, quote, a petitioner who chooses not to call trial counsel as a witness at an evidentiary hearing will, as a practical matter, almost never overcome this presumption. So
almost never, but are you saying that on this record that the habeas court had insufficient facts to apply to the two-prong Strickland test?
Yes, Your Honor.
How so?
Well, first of all, in the absence of testimony of counsel, we have effectively no way of knowing, the Superior Court had no way of knowing why trial counsel did not press harder to obtain the treatment records of the witness, or what factors went into trial counsel's decision. Critical factors that are on the record in this case that we can tell simply from what we do have are that the trial judge, not the habeas judge, but the trial judge in the original proceeding had already effectively ruled that the treatment records were irrelevant, in that the trial judge had said the only real relevant question here is whether the witness was under the influence of mind-altering substances at the time that she witnessed the crime. The treatment records in question date to 1996, when the witness was discharged from treatment, and describe an 11-year period of drug use leading up to that 1996 date. The crime in question happened here in 1998. The trial then happened a couple years later.
Excuse me, you would agree, however, that the fact that she had a substance abuse problem and was deemed to be a psychological liar, that should have been at the least attempted to be introduced into evidence. That goes to the credibility of the witness.
Well, Your Honor, I have two issues with that. First of all, that quote, that excerpt, that she was a pathological liar who would do anything to suit her desires and fantasies. I think this really illustrates the danger of taking small quotes excerpted out of context. If we look at the Third Circuit's opinion on direct appeal.
That's not the question, because I don't know, I'm talking about the introduction or the attempted introduction, whether it is that phraseology or not. The fact that there is an issue as to the credibility of her test or testimony, that in of itself, regardless of whether she's a pathological liar or whatever, but that attacks any evidence that attacks a witness' credibility is important or essential, is it not?
Yes, Your Honor. I certainly agree that any evidence that attacks a witness's credibility is important. However, I do not know, or I do not think that the evidence in question here goes to the witness's credibility on this issue, as the trial judge found. A prior history of drug use says nothing about whether the witness was in any way impaired several years later when she witnessed the crime, and says nothing about her credibility to testify to what she witnessed.
When did the trial judge make that ruling, though? That it was inadmissible or not necessarily germane to the issue?
Well, Your Honor, the trial judge did not have these records in front of him and did not rule specifically on that. However, during the cross-examination of the witness, there was a sidebar, at which point the trial judge ruled that really the only relevant question, the only reason to inquire into the witness's history of drug use was to determine if the witness was under the influence at the time of the murder that she witnessed, and therefore not credible. Effectively ruling, we can infer that her credibility during the period of her active drug use prior to that is not relevant. It doesn't establish whether or not she was under the influence at the time she witnessed the murder, and is really irrelevant to her credibility on that matter in that context.
What is the second prong of Strickland?
The second prong of Strickland is that the petitioner must show that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. In this case, of course, we do not believe there were unprofessional errors in the context of obtaining Weeks treatment records, but putting that aside for the moment.
Well, assume for a minute that counsel's conduct was outside the scope of professional conduct, so that Mr. Maynard prevails on that first count. What about the second count, the second test, the second prong of that test?
I understand, Your Honor. Even Assuming that the Superior Court were affirmed as to the first prong of Strickland, as to the second prong of Strickland, there is no reason to believe on the record we have in this matter that the results of the proceeding would have been different.
Well, what
First-
facts,
Yes.
what facts were proved? What do you
Certainly.
have?
First of all, there was a second eyewitness, Adolf Hyman Jr., who was there at the time his father was shot and killed. He also independently testified and identified Maynard as the shooter.
But did he actually see Mr. Maynard shoot his father, or he said he had passed Hyman Sr., he and Miss Weeks, and he looked back and he saw Mr. Maynard with, I believe he described as a long gun. Am I correct?
No, Your Honor, I believe Hyman Jr. described a handgun.
Handgun. But did he actually testify that he saw Mr. Maynard shoot Mr. Hyman Sr.?
He testified that he saw Mr. Maynard with a gun in hand running after them as they fled, and that shots were fired. I am not entirely clear if he was looking at Maynard at the precise moment the shot was fired, or if he simply saw Maynard with the gun and heard shots being fired as he ran away. But he did see Maynard with the gun as shots were being fired, and Hyman Sr. was shot and killed.
So the only witness who actually testified that she saw the shooting was Miss Weeks. Am I correct? The common law wife of Hyman Sr., Miss Weeks.
I'm not entirely sure that Hyman Jr. did not actually see the moment at which Maynard pulled the trigger and fired. I could double check that later, Your Honor, but I do know that both of them were present at the scene, heard shots, saw Maynard with the gun moving toward them. They were running from Maynard, coming toward them with the gun, shooting.
Your time is up.
Just one more quick
Yeah.
question, please. What other evidence is there besides that testimony?
Other than Hyman Jr. and Weeks' testimony, there is also good evidence as to Maynard's motive, given the previous altercation at St. John 4th of July Carnival, and probably most importantly, his flight from the jurisdiction under an assumed name only 48 hours after the shooting in this case.
But
Both of those are circumstantial, but those together with the eyewitness testimony of Hyman Jr., even without Ms. Weeks' testimony, is certainly.
Wasn't the victim in this matter involved in other verbal or even altercations with other people?
I apologize. Could you say the question again, Your Honor?
Was the victim in this case also involved in altercations, be it verbal or otherwise, with other people besides Mr. Maynard?
Not to the same extent, certainly, Your Honor. Nothing of the magnitude.
I don't understand. You say not to the extent. Was he involved in other arguments or otherwise with other people?
The victim, Your Honor?
Yes, the family, Mr. Hyman, was he involved? Didn't they come out that he was also involved with other arguments? I believe it was in the village or some other place.
Well, Your Honor, certainly everyone has a history of quarreling with people in the ordinary context of life, but
Now, that may be true, but I'm saying, didn't it came out that there were other arguments that the victim was involved in with other people? I'm talking about, I'm just asking because you said the fact that he was involved with arguments with Mr. Maynard. And I'm saying to you, was he not also involved in other arguments with other people?
Right. You can answer the question on your rebuttal time.
thank you. Thank you, Justice.
Right, Mr. Manning?
Good morning. My name is Johanna Manning, and I represent the appellee, Kendrick Maynard, the appellee in this case.
Mr. Manning, you're going to have to speak up.
Thank you. Good morning. My name is Johanna Manning, and I represent the appellee, Kendrick Maynard. There was no physical evidence in this case that my client.
Right, Mr. Manning, you're going to have to stop and adjust your volume.
Okay, testing 1 2. Testing 1 2. Can you hear me now, Justice Correct?
You're going to do a little better than that.
Okay, good morning.
Just a minute, just a minute. We'll break for 5 minutes.
All right. rise. Recess is over. This court is now in session. The Honorable Maria M. Cabret, Associate Justice. The Honorable Harold W. L. Willax, Associate Justice. The Honorable Jomo Mead, designated. Please be seated.
Very well. Attorney Manning, you may proceed.
Thank you very much. Good morning. May it please the court. My name is Johanna Manning. I represent the appellee in this case, Kendrick Maynard. Our argument is that the underlying trial court did not commit clear error in finding that trial counsel's conduct was objectively unreasonable when it found that failure to procure Mrs. Weeks's medical records was objectively unreasonable. We submit that the basis of his finding was not clear error insofar as the conduct of trial counsel was on the record. In other words, the court found that the defense counsel's failure to procure those records pre-trial and or during the trial was objectively unreasonable. Those records came in after the parties had rested, after the defense had rested. The trial court asked defense counsel whether or not he sought the court's assistance in obtaining those records. He said no. Whether or not he requested a brief continuance to review the records prior to closing, he did not. Based on those facts, the court was not clearly erroneous in finding that the conduct was objectively unreasonable. In this case, there was no physical evidence linking my client to the shooting and or killing of Adolph Hyman Sr. The other evidence that was referred to was testimony from Adolph Hyman Jr., whose testimony was impeached. As is clear on the record, Adolph Hyman Jr. testified that my client pulled out an AK-47 from his waistband, which is clearly impeached because the jury can infer that it's impossible to carry an AK-47 within your waistband. Adolph Hyman Jr. did not testify that he saw my client shoot and or kill his father. He testified that my client was in possession of a firearm, but that's not evidence that he actually did the killing in this case. The principal evidence was from Ms. Weeks, and the evidence on the record is that Mrs. Weeks had.
Let's turn away from the facts for a minute and turn to the law that applies to this case and to your client's burden, Mr. Manning. What is the standard that this court has adopted for ineffective assistance of counsel?
It's a two-part test. First, the trial counsel would have had to be his conduct would have had to been objectively unreasonable, and but for that conduct, there's a reasonable probability that the outcome would have been different. In this case, we argue that both prongs are satisfied. Objective unreasonableness based on the fact that he did not procure those records. And then it would have been different in this case. And we submit that because—
With regard to the analysis conducted by the trial court in this case, how did the trial court analyze that second prong?
He analyzed the second prong because he found that those records would have been material in the outcome of the case. Insofar as those records would have done two things. Part one, my defense counsel was limited in his cross-examination because there was a question as to whether or not he had a good faith basis to inquire further of the mental state and or the assertion that Mrs. Weeks was addicted to crack cocaine or a crack addict or a crack user.
Excuse me.
The fact that, yes,
Let's take Ms. Weeks out of the equation.
yes.
Okay. Is there, be it circumstantial evidence, but is that not enough for the jury to have found Mr. Maynard guilty? Even if Ms. Weeks didn't testify?
We submit that the evidence would not have been sufficient. Obviously, the testimony of Adolph Hyman Jr. that he saw my client with a firearm and running in the direction of the three individuals is evidence that my client potentially was the shooter.
And then
But it was impeached.
And then there were several, what was his testimony as to running toward the individual impeached, or the fact, like you stated, that he pulled the AK out his waist? And was it also impeached that he shortly heard several shots fired? Was that also impeached?
Absolutely, Judge. The evidence, the evidence as it came in, Judge, in our argument, was impeached, which would then go to the credibility or a credibility assessment of Adolph Hyman Jr. We submit that evidence was questionable, was shaky, and the jury could have.
I'm sorry. According to your argument, the AK-7 was impeached because, according to you, it's virtually impossible to pull out an AK out of a person's waist. The other part of the testimony as to his hearing the shots and so forth, was that also impeached? And if so, how was that impeached?
The evidence of hearing of the shots, no, that was not impeached. The evidence of what type of firearm was used to kill Adolph Hyman is what's in question here. Adolph Hyman Jr. stated that he had a handgun. At trial, his testimony was that he had a handgun. The murder weapon in this case, obviously and clearly based on the record, was an AK-47. Therefore, the jury, in finding that my client would have been would have fired the fatal shot, in and of itself would not have been sufficient to find that he killed the Adolph Hyman Jr. So that's our argument. The testimony of the AK-47 and things of that nature came from Maria Weeks, which, if that was not included in the case, then I believe that the jury would have had insufficient evidence to find my client guilty.
Thank you. Continue.
With regard to the question that I asked you as to how the trial court analyzed the second prong of the Strickland test, would you answer that question, please?
Yes. So the court, in finding that the result, there's a reasonable probability that the result would have been different. The court found that had these records been available pre-trial or during trial, then the defense counsel would have been able to enter that evidence into the record that would have challenged the credibility of Mrs. Weeks. That's how the court, that was the basis of finding that the second prong was not satisfied. Our argument goes a step further, insofar as defense counsel was limited in his cross-examination.
So, well, I want to stick with the second prong, Mr. Manning. Did the court consider Mr. Hyman's Jr. testimony at all, the testimony of the son, when he was analyzing the second prong of the Strickland test?
Not directly in the opinion, but we submit that it appears from the record, and it appears from the opinion.
I'm talking about the opinion, Mr. Manning. We can't read between the lines in an opinion. We don't have a crystal ball to read what is not there. We have to read what is there. With regard to the court's analysis, the court's opinion is a total of 58 paragraphs, and with regard to the second prong of the Strickland test, the trial court devoted 2 paragraphs to that second prong.
Yes.
The trial court did not consider, when it was analyzed in that second prong, the testimony of Mr. Hyman Jr. Did it consider any other circumstantial evidence?
Not from the opinion, not from the 58 paragraphs itself. We just submit that there's an inherent belief. Well, we believe that he inherently considered it in finding that the evidence of Mrs. Weeks was a critical and/or deciding factor in the verdict. So, in our view, it was an inherent rejection of the sufficiency of the evidence as it pertains.
Well,
to,
was it an inherent rejection of the sufficiency of the evidence, or was it an inherent rejection of the second prong of the Strickland test?
Well, our position is that he found that the materiality of Mrs. Weeks' testimony was vital to the rendering of the verdict in the manner that the jury rendered the verdict. That, in our view, that materiality demonstrates the court's rejection of the sufficiency of Adolph Hyman Jr.'s testimony in and of itself. And there being no other physical evidence that links my client to it, we submit that opinion shows that the court found that a critical or deciding factor in the jury's verdict was the testimony of Mrs. Weeks. That's our argument as it pertains to how the court evaluated the second prong and how he evaluated the materiality of that evidence.
Thank you.
Thank you.
Did you have any other
So
arguments?
Absolutely. Our view is that based on the fact that the court had elevated and isolated that testimony of Mrs. Weeks, that goes to show the justices that his analysis and his view is he's rejecting and or setting aside the impeached testimony of Adolph Hyman Jr.
But is that-
which is not direct evidence.
Is that your interpretation, or you're merely reading in between the lines and assuming that he rejected? Where in the opinion did it say he's rejected, or that supports your argument?
No, I mean, there's no direct rejection by Judge Brady in his opinion. We're just arguing that the opinion of it in and of itself appears to show that he rejected the testimony of Adolph Hyman Jr. in the rendering of that verdict, and he then isolated the testimony of Maria Weeks being the critical or deciding factor in the verdict in this case. I mean, that's just our view, and our argument is when we analyze Judge Brady's opinion, that's what is obvious on the record to us as it pertains to any other evidence, and this evidence being vital and or the deciding factor in the rendering of the verdict. Therefore, I mean, there's a rational basis in the court finding that this was a critical and or deciding factor in its opinion. Thus, his opinion was not irrational. It was not illogical. It was not arbitrary and or capricious.
Does that conclude your argument?
Yes, ma'am. Thank you very much.
No?
Justices, with my rebuttal, I would just like to take the opportunity to correct a couple things. We heard Attorney Manning refer to clear error, but that is not the applicable standard here. This is a de novo review on a habeas petition. This court is free to review the matter in the first instance, so any error will suffice. Secondly, Attorney Manning alluded or stated that the second prong was satisfied because if counsel had investigated the witness's treatment history, then that evidence would have been admitted into the record and all the other inferences that follow. The court, the Superior Court in this case, did not discuss or mention the issue of admissibility of that record, even if it had been procured, and indeed there are problems with admissibility in this case. The obvious one being hearsay. There's also federal regulations that apply and give specific protection to records for substance abuse treatment and only allow for disclosure in order to prevent death or suicide, things like this. They may or may not have applied in the end, but the point is the Superior Court did not address those issues. The petitioner made no argument as to those issues. Both the petitioner and the court simply assumed that had counsel investigated this drug treatment record, it would have made a sweeping difference in the trial. In fact, in the Superior Court's opinion that Justice Cabret was alluding to, in those 2 paragraphs that address the second prong of Strickland, all the Superior Court says is that Weeks' credibility as a witness would have undoubtedly been seriously affected, and that considering the totality of the evidence, the court finds that the inability to present at trial this evidence that was with diligence available to his counsel likely had a pervasive effect on the inferences to be drawn. And that's just a quote from Strickland. There is no discussion of any of the other evidence that pointed toward a conviction in this case. No mention of Hyman Jr., no mention of the circumstantial evidence, the motive, the fact that Maynard fled from the jurisdiction immediately after the crime in this case. And then
With regard to other evidence, I think you owe Mr. Bailey, Justice Willox, an answer that your time was up when you were answering
yes.
Justice Willox's last question.
Yes, Your Honor. I was curious if Justice Willox has a specific altercation in the record that he is referring to, because to my knowledge, there is no specific altercation between the victim in this case, Hyman Sr., and anyone else that would have risen to the level of it providing an alternate motive for the murder in this case, given all the other facts.
But didn't a gentleman testified electronically from St. Kitts in the habeas proceeding and testified that the Hydeman had a confrontation with other persons other than Mr. Maynard? I think that's what Justice Willox is referring to.
Yes.
The testimony of the witness in the habeas hearing?
Yes.
Yes, Your Honor. However, I think that is ultimately immaterial to the ineffective assistance analysis. That witness was not there during the original trial of this matter. That testimony was not a part of the case, and it really doesn't go to whether or not counsel should have investigated Weeks's history of drug treatment, those records, or whether the failure to do so would have resulted in a different trial.
You mentioned motive. Does that not give rise to other people having motives to commit such an act?
Perhaps it does, Your Honor, but only in retrospect. The motive is only relevant here insofar as the second prong of Strickland is concerned, which is had Weeks' treatment records been found, would it have changed the outcome of the trial as it happened back in 2002, or 2001, where that testimony was not present before the jury. So the question of would it have affected the outcome of the trial, no, it could not have, because that testimony was not available.
Well, isn't that basically the argument that defense counsel failed to do all these things, that the fact that there was another confrontation, because you were the one who raised the issue of motive, that there was an argument. I merely counted that there was another argument, which would go to your sole issue of motive, that there may be others out there that may have a motive, that may also have a motive. So the fact that that was not raised, does that not support the arguments made by Maynard in terms of ineffective counsel?
Well, Your Honor, just to, I see my time's up, but just to
You answer the
briefly,
question.
just to briefly answer. I think that it does not illustrate a different problem or ineffective assistance on the part of counsel in this case. First of all, the issue of those other witnesses and their availability with the finding of the AK-47, all of that was addressed. The Superior Court did not rule on those grounds, did not grant habeas relief on those grounds, and the appellee has not challenged that ruling. So that matters not before the court. But most importantly, Your Honor, motive in this case is, the point is not that there is one single definite motive, but rather that all of the other evidence together, including a potential motive, the fact that Maynard fled from the jurisdiction, and most critically, the testimony of Hyman Jr. also all establish Maynard as the shooter in this case. And if I just may, to answer Justice Meade's, designated Justice Meade's questions earlier and clear up this little difficulty. Adolph Jr. testified that he saw Maynard approaching them rapidly on foot, brandishing a firearm that Adolph Jr. described as a big gun. This is from the Third Circuit's opinion on the direct appeal. And finally, all three turned and fled, and Adolph Jr. soon pulled ahead of Adolph Sr. and Weeks. Adolph Jr. testified that he looked back as he ran and saw Maynard right behind Adolph Sr. shooting after him. And that is the nature of Hyman Jr.'s testimony. And with that, if there's no further questions,
Well,
thank you, Justices.
thank you. We'll now address Reese Richards versus Public Employees Relations Board and Government of the Virgin Islands Police Department. Proceed.
Thank you. Good morning, Justices, and may it please the Court. I also want to congratulate...
I'm sorry, speak into the
I'm sorry.
microphone and please state your name for the
Yeah,
record.
I'm sorry, Your Honor. Ryan Stutzman for Reese Richards. And may it please the Court. I also wanted to congratulate Justice Willox. I was hoping to be the first argument today so I could say that in perpetuity, but I lost that to Attorney Beckstead. But
Thank you.
I'm here today. This case is about Title III Virgin Islands Code Section 530, which I think some, if not all of you, are familiar with, provides a procedure for the certain VI government employees to contest adverse employment decisions, and that's by appeal to the PERB. In this case, my client was suspended in 2004, and she did not receive the due process that she's entitled to under Section 530 because the PERB decided that it didn't have jurisdiction. And the Superior Court affirmed that decision. In so deciding, PERB and the Superior Court, just using a colloquial term, pulled the rug out from about 40 years or more of settled understanding of what the purpose of Section 530 is, which was and is to give employees an avenue to contest adverse employment decisions. All the way back to 1958, if not before, the courts of the Virgin Islands have been applying Section 530 to provide this avenue for Virgin Islands employees to contest these adverse employment decisions. And the case that I found back from the 50s is Felix versus Government of the Virgin Islands. And that's cited at 167 Federal Supplement 702.
Mr. Stutzman,
Yes,
you need to stay close to the microphone.
I'm sorry.
And I also neglected to ask you, how much time do you want to reserve for rebuttal,
Oh,
if any?
5 minutes, Your Honor.
Okay, very well.
And so all the way back to 1958, we have that case applying Section 530 in favor of a police chief back at that time. My client also worked for the police department. Over the years, Section 530 has been expanded, only expanded every time, to WAPA employees in 1973, to Port Authority employees in 1983, to the Government Development Bank and the hospitals in 1999. And all the way to the present day, Your Honors, I don't think there's anyone who would dispute that 530 applies to an employee such as my client in the Virgin Islands Police Department, with the exception that we're looking at in this appeal, which is for the brief life of an amendment that was passed in 2001, and that lasted until 2005, when it was amended again. The government argues that this amendment limited PERB review to employees of certain instrumentalities. Those at the time being the Development Bank, WAPA, Port Authority, and the hospitals. But this amendment, and you'll see in the joint appendix, put all the legislative history in there, and Senator Canton at the time was trying to correct something that apparently the hospitals asked him to do, which is, I guess, some probationary employees had been seeking 530 review.
Well, both PERB and the Superior Court on Review ruled that the statute has a plain and unambiguous meaning, and hence that the PERB had no jurisdiction. You obviously disagree with that interpretation of the statute. So what is your interpretation of the statute?
Yes, Your Honor. I submit that this statute is ambiguous. It's clearly ambiguous because of a couple things. Number one, Your Honor, the statute starts out talking about department heads, okay? And department heads is defined in that chapter, Chapter 3, or I'm sorry, Title 3. And department heads are the heads of executive branch departments. And so...
Was that the definition at the time of the amendment of the statute?
I'm virtually certain, Your Honor. And so, furthermore, it says that the department heads under this statute include, and then it lists off some of these instrumentalities. Well, the word includes, Your Honor, has been found to be inherently ambiguous. What does include mean? You know, it's expansive. It's an expansive term, not a restrictive term. And when you look at the legislative history and how this has been applied since at least the 50s, it's always been to give a remedy to employees who feel that they've been suspended or terminated without just cause. And so Your Honor, this 2001 amendment, it was inartfully drafted. It's been and with all due respect to the legislature, it's been kind of
But why is it ambiguous? You're saying you've mentioned two reasons, but I'm not clear on what your argument really is. You are saying that the term including is not a limiting term, it's an expansive term. That's one of your arguments, right?
Yes, Your Honor.
Ergo, it's an expansive term, meaning?
It's an expansive term, meaning that it's not necessarily limited to those listed instrumentalities, the heads of those listed instrumentalities.
But then, would it not say included but not limited to? Would that not be the phraseology? But once the word included, one can rationally or logically interpret that to be including whatever else is listed. It seems like your argument goes towards the including but not limited to, which would then be expansive. But the including, to me, would suggest only those agencies or instrumentalities that are listed below.
Your Honor, including has been discussed in the recent case of Esperson. That's Atlantic Human Resources Advisor v. Esperson, which is a case actually that the government cited in support of its own argument. And Esperson says that the word including in a statute is, and I quote, necessarily ambiguous and a term of enlargement. So you have to go to the canons of statutory interpretation, which include the legislative history and how this has been applied.
Let's stop here one quick second. Including, yes, expansive. And then you have a list of what else is included. So at the end of that listing, that's it. So yes, including is expansive, but however, the including is specified by statute what is included. Is it not?
No, Your Honor, I would submit that including is a term that from which a list can follow, but does not encompass everything that the statute intends to encompass. And again, Esperson calls that word necessarily ambiguous.
But then statutory interpretation would then state, had the legislators intended to not put a limitation, would have said included but not limited to, which then would support your argument. But the fact that they said including and merely did a listing, and at the end of the listing put a period, does that not end whatever was meant to be included?
No, Your Honor, and I don't think that but not limited to is necessarily follows the word including. I think, in fact, it's under Esperson that but limited to is a superfluous language. Including means including, and there can be other things. And again, Your Honor, when you look back at the history, they added every time that they amended this statute.
I don't disagree with you on that. Since 1961, this statute has been amended several times with the intention of including more and more employees so that more and more employees can have due process. I don't disagree with that. What we're looking at here is the language of this particular amendment to the statute. Both the PERB and the Superior Court, as I indicated earlier, ruled that the plain meaning of the statute precluded the PERB from exercising jurisdiction. You're saying the statute is ambiguous, and hence we have to go to the history of the statute, its intent, et cetera. But we only get to the history if the statute is ambiguous.
Yes, Your Honor. And the other thing I would add is that a department head, which is defined at Section 451 as the head of any executive department, it doesn't make any sense to say that a department head could discharge or suspend or otherwise take adverse action against an employee of WAPA or a Virgin Islands Port Authority. And I want to add, Your Honor, the case of matter of LOF, where I think it was authored by Your Honor, Justice Cabret, which says that statutes should not be read literally or restrictively, where to do so would defeat the purpose of the statutory scheme and produce an unintendable result. And here we have a statutory scheme which since at least the 50s was used to protect, at least give these employees a remedy or a procedure, and with the construction the government wants to give it now, for that very narrow window of time, Your Honor, would remove that remedy. And then I will also want to raise Williams-Jackson, that 52 VI 445, where the exact same issue, at least a substantially similar issue, is raised by Your Honor in Note 5. It looked at the same passage in the same statute and came to the conclusion that, that the statute is meant to protect all Virgin Islands executive branch employees who qualify, not just the listed instrumentalities. The court called it the legislature's obvious intent. I'm putting that in air quotes. The court should do the same thing here. I'm running out of time. I have a retroactivity and waiver argument in the briefs, but I'll save some time to rebut.
Very well.
Thank you, Your Honor.
Good morning, Justices. Assistant Attorney General Sean Bailey on behalf of Appellee Virgin Islands Police Department. Just to address a couple things in what counsel just said. To the extent there is an ambiguity in 530, that ambiguity is only as to the first part of the statute, as he just stated, including, which is the list of department heads, or in this case, employers, bosses, who can
Attorney Bailey, would you put that microphone, thank you.
Yes, apologies, Your Honor. So as I was saying, to the extent there's any ambiguity in Section 530, it only applies to the first part of that statute, which is where the legislature has listed the officer, the department head doing the firing. What is not ambiguous is the directive and the explanation as to who qualifies, as to who is being fired, which is employees of the listed instrumentalities in the statute. There is absolutely no ambiguity there. The meaning is plain, and therefore there is no need for the court to resort to legislative history. Williams-Jackson as well, which was mentioned, that case dealt with a different version of the statute and a word that was left in the statute, evidently by accident, but most importantly, the Williams-Jackson language that counsel was referring to appears in a footnote, was not raised and argued by the parties, and was not critical to the holding of that case. And in that respect, it's dicta and not of precedential value in this case. But I think that the court has covered the issue of the statute itself well. I would like to turn instead to the second argument in our brief, which is based on the idea of judicial estoppel. And that argument is that the appellant has claimed in the past in other cases before the PERB and the Superior Court related to the same events giving rise to this case, that she was in fact a classified and unionized employee covered under the collective bargaining agreement during the relevant time period. And in fact, appellant has obtained a judgment under those terms where she argued that her rate of back pay should be calculated based on her membership in the union and the rates established by the collective bargaining agreement during the relevant time period. She has benefited from that representation to the court to the tune of hundreds of thousands of dollars. And now here in this case, the appellant would have us believe that she was not a member of a union, not covered by the collective bargaining agreement, and therefore subject to relief under
But
530.
when she was suspended, was the CBA in effect?
No, Your Honor.
Well,
The
okay.
CBA was not in effect at that time. However, the collective bargaining unit had been certified.
Why is your judicial estoppel argument not waived?
The judicial estoppel argument is not waived in this case because these are relatively extraordinary circumstances, Your Honor. First of all, the issue was originally brought up before the PERB all the way back in 2004, but given the state of the statute at that time and the fact that PERB was regularly dismissing these types of cases in terms of, or with respect to people before it from all different instrumentalities of the government on the basis that they had no jurisdiction, it seemed clear that the outcome would be that. And so, yes, the government did, the Virgin Islands Police Department did abandon that argument originally before PERB. However, Section 530B does say that in the event of extraordinary circumstances, even things not raised before PERB are not waived. What's extraordinary about this case is that it lasted so long and languished on the docket for so long that in between the original filing of this case, first in PERB and in Superior Court on writ of review, and when it finally came up again before the Superior Court in 2022, a whole number of other cases, related criminal PERB matters had come up, been argued, resolved, and decided, including the ones that I am referring to, where Richards represented that she was covered under the terms of a collective bargaining agreement. And this is specifically in terms of a 2004 PERB case, same as the year of the PERB case underlying this matter, and took that to the Superior Court on a writ of review, maintained that position, and ultimately derived substantial benefit from that position on the basis that she was covered by a collective bargaining agreement. Admittedly, that was not, did not enter into force until 2005. However, Richards herself has taken the position, it's on JA 140, that she was a classified and unionized employee and therefore entitled to back pay under the terms established in that collective bargaining agreement, even though that collective bargaining agreement wasn't signed until 2005 and the back pay in question dates to 2004. So, those are extraordinary circumstances, Your Honor. From the time this case was originally filed, everything that happened in between, the new arguments advanced by Richards in other related matters, the judicial estoppel argument obviously would not have been available until she asserted that position in other matters before other courts. And so only then, in 2022, when this matter came up again in the Superior Court, was all of that history there for the Virgin Islands Police Department to assert this position, make its judicial estoppel argument, and say effectively, Richards cannot have it both ways. She cannot, in one case before the court, suggest, I am covered by the collective bargaining agreement and obtain relief according to its terms, and then turn around in this case a few years later and say, I am not covered by the collective bargaining agreement, and so I should receive recovery under 530.
When did the Virgin Islands Police Department first assert this estoppel argument?
Well, originally, in this case in 2004, in PERB, it was raised. They ultimately,
And when was the next time?
I believe, 2022, when this case was resurrected in the Superior Court, when the Superior Court reached out to Richards and asked if she was going to continue prosecuting this writ of review. It was really the first instance since those positions were taken, since those parallel cases were worked out, that the government had opportunity to address this issue in this case. and so really the first possible opportunity to assert judicial estoppel. One last piece on judicial estoppel. I would simply like to read the quote of this court, that the doctrine of judicial estoppel rests on the basic notion that absent any good explanation, a party should not be allowed to gain an advantage by litigation on one theory and then seek an inconsistent advantage by pursuing an incompatible theory. That is effectively exactly what Richards is attempting to do in this case. She's already recovered on the theory that she was covered by the collective bargaining agreement in one case, a related case arising from almost the exact same facts that originated in the PERB in the same year. And yet, here she is coming before the court now saying, no, I should be entitled to recover under 530 because I was not covered by the collective bargaining agreement. Those positions are by definition inconsistent, incompatible, and must be barred by the doctrine of judicial estoppel.
All right, it's, with regard to the first argument, is the Virgin Islands Police Department conceding that the words department head within that 2001 amendment ambiguous?
No, Your Honor. We're not conceding that that piece of the statute is ambiguous. My intention in bringing that up was simply to point out that appellant's argument on ambiguity only applies to one small portion of that statute and not the operative portion of the language that we're really dealing with here, which is which employees of which instrumentalities are covered.
So you're saying that appellant's argument applies to the words department head, the first part of the statute?
As I understand appellant's argument, Your Honor, yes. It's an argument that there is ambiguity effectively as to who can do the firing or the suspension, but not ambiguity as to the person being fired or suspended who would actually be seeking relief from PERB. But regardless, Your Honor, on the topic of the statutory interpretation, in terms of the statute as a whole, there is no ambiguous language that leads us, in this case, that requires us to resolve any ambiguity one way or another, right? Even if the statute is perhaps ambiguous in the abstract as to that word including, in the case before us, that is not relevant to deciding this case. In this case, the part of the statute that we are interpreting is, was the appellant employed by one of the government instrumentalities covered under Section 530? And on that point, the statute is unambiguous that only those four listed instrumentalities are covered. This court has in the past, in People v. Todman, this court cited to a Third Circuit case in which called Friedrich versus U.S. Computer Services. In that case, the court said, in interpreting a statute, we must start with the language of the statute itself. Although a statute should be interpreted in a fashion that does not feat legislative purpose, a court may not rewrite an unambiguous law. Even if the court does not believe that Congress intended a specific outcome when it drafted a law, the court must give effect to the unambiguously expressed intent of the legislature. And I think that holds true here. The court went on to say there that even if it seems implausible to deny the administrative agency, in this case the Department of Labor, regulatory power to impose labor standards over drivers of vehicles in interstate commerce, the legislature and not the judicial branch of the government has the responsibility to expand the agency's regulatory power. So in this case, Your Honor, appellee submits that the legislature stated its intent unambiguously. In the language of the statute itself, there is absolutely no need to take recourse to the legislative history or look for legislative intent. The first step of the first canon of statutory construction is plain and unambiguous language, and if we have that, we need look no further. And that's what we have in terms of the way that Section 530 needs to be applied in this case. If the justices have no further questions.
We have no other questions, so.
Thank you, Justices. I'll rest on our brief then.
Your Honor, Your Honors, just a few points. Number one, there's been a lot of discussion, both here and in the briefs, about what's happened in other matters that is not in the record before you.
Are you referring to the argument of judicial estoppel?
I'm referring to the assertions of counsel that my client litigated some matter and got money. That's not in the record before this court, okay? That's number one. Number two, counsel is mixing up the termination and the suspension matter, which...
Okay, just a minute. So with regard to the judicial estoppel argument, what your argument is that there are no facts to support the argument of judicial estoppel.
That's one of my arguments.
Okay?
Okay, and further, Your Honor, there are several related cases. One is a termination case. One is a suspension case. We're here today on the suspension case only. My client has not been provided any remedy or money on the suspension case. And we need to talk about the timeline of unionization and the CBAs in this matter. My client, there's nothing to hide here about her union status. And that, yeah, she was covered by a CBA. I don't have the date in front of me, but I believe it was sometime in 2005 or 6 that the CBA with the United Steelworkers came into effect. But the Maritime Union decided that they were going to leave the territory, I think in about 2002. And shortly after that, their day-to-day contract expired. So there was no CBA for about a 3-year period of time, give or take. So there is no inconsistency, there is no estoppel, because for a certain period of time, she was not covered by a CBA. She was unionized by the United Steelworkers after they moved in, but the Maritime Union's CBA had expired, and there was a gap with no CBA coverage. Okay, now I want to talk about waiver. As I say in my brief, the way the government has gone back and forth about their positions is pretty astonishing in this case. First, as to the appellant's union status, and I have a chart I think will be very helpful for you, I think on the first page of the reply brief. The government said in 2004 during the PERB hearing, respondent is prepared to retract its objection to respondent's access to PERB because of union membership. We are not only prepared to, we do. So they retracted the position based on my client's union membership. And as you may or may not be aware, the statute says if there's an objection not raised before the PERB, that objection is waived. And so by retracting that position, they've now waived that position. And then later on, Your Honor, now the government is saying that that the statute is ambiguous. Well, Your Honor, in the briefing in 2002 to the Superior Court, the government looked to the decision of Angel v. PERB which is at 73 VI 89, that's a 2010 Superior Court case, and said that the PERB lacked jurisdiction to hear this matter, but not for its stated reasons in its November 2004 decision. So in this case, again, it's backtracking on saying that the statute is ambiguous. It's saying in this brief that, no, we think now that the PERB was wrong. So we want to go back to our union argument. So first they waived the union argument by retracting it at the PERB. Then they retracted their argument about ambiguity to the Superior Court. So I've never seen this in all my years of practice, but it's like this is a double waiver. And they can't go back and forth with their positions like this with no consequences. Thank you, Your Honor.
Welcome. We take these matters under advisement.